A pleasant day to everyone. Let's now move on to the part 7 of the book 1 of the criminal law. This is now on the exempting circumstances. Once more, this is Mr. Ariel Diman Luzok, the director of the ADM RC. Okay, so let's now define what an exempting circumstances is. Exempting circumstances is defined as that circumstances wherein there is one thing in the agent of the crime, any of the condition which makes the act voluntary or negligent, meaning there is lacking element no in the commission of a crime, which we have discussed actually in the second part of our discussion of criminal law book 1, which is the so-called the elements of dolo or deceit or culpa or fault. Okay, so once any one of those elements are is rather missing in the commission of a crime, there is a crime, but the offender might be exempted from criminal liability, although there is a civil liability. Why? Because as you can see from number one item, exempting circumstances is still proves that a crime was committed. It is the act is considered still unlawful. There is a crime, but there is no what criminal liability. There is a criminal on this part, but the one who directly execute the crime may not be criminally liable, but there is a civil liability with exemption of one, the paragraph 4 of Article 12, which is the accident. Why? Because once the thing is a pure accident, which we know it is something that happens beyond the sway of our will, of man's will, that pure accident will make the person not criminally and not civilly liable. Okay? Now, the reason, as we said, there are four reasons. One, complete absence of intelligence, just like in the case of minors and insane and imbecile. Two, lack or complete absence of freedom of actions, just like in the case of those people who act under the compulsion of an irresistible force or those who commit an act under the impulse of uncontrollable fear. Okay? And the third one is the lack of intent. This is applicable only to dolo or deceit. To dolo or deceit, yes. While negligence or imprudence, the absence of that is applicable on the part of culpa or fault. Now, let us discuss the different kinds of exempting circumstances. But by the way, when we speak of negligence, that is more of the concept of lack of foresight, while imprudence is more on the concept of lack of skills. We will go through that further as we go along with our discussion of the different kinds of exempting circumstances. Okay, so let's have now the circumstances. The first one is imbecility or insanity. Okay, what is imbecile and what is an insane? They have a distinction. An imbecile is a person suffered from mental retardness, meaning his age might have forward already, but the mentality or IQ was left behind. So an imbecile is actually a person although whose age is already at certain legal age, but the mind is similar to a child of 2 to 7 year old. Thus, he lacks what? Intelligence. Okay? And because of that lack or complete absence of intelligence, this child is exempted. No? This person is exempted from criminal liability, but the parents or the guardian will be accounted for the civil liability. Okay? Actually, imbecile is only one of the kinds of mental retardness. The other one, which is worse, is the so-called idiot, which is similar to a child with an age of 2 years old and below. Okay? And the third one is the moron, whose mentality is similar to that of 7-year-old up to 14-year-old or 12 years old. Okay? So practically these three can be considered exempted by reason of lack of intelligence. The second one is the insane. The insane is not automatically exempted compared to imbecile. Why? Because insanity is a mental illness whereby a person with this condition might have a time of sanity, or we called it the lucid interval. What is lucid interval? It is the period of time at which an insane is under a rational thinking, meaning he is of sound mind. So he know what he is doing. So therefore, if the person's suffering from insanity commits a crime under lucid interval, he can be held responsible for his act. And what does it mean? The trial of the case can pursue. Although during arraignment, if the person's insanity, okay, appears, then the arraignment of the case can be suspended by the court. But if the person commits a crime not during the lucid interval, then the condition is just like the same with imbecile. He is exempted from the criminal liability but subject to the payment of the civil liability, okay, committed against the victim. Okay, so the second one rather is in the case of minority. We know that a minor, okay, is also exempted somehow because of the lack of intelligence. But in the old law, under the original provision of the Article 12, paragraph 2, what is exempted is 9-year-old below. But because of the amendatory law, which is the Republic Act 9344, the age was raised to 15-year-old and below. So the moment a child of age 15, take note, starting from 15 down, 14, 15, 13 down the line, once they commit an act which is against the law, okay, they are automatically exempted from the criminal liability. Now, what is the rationale? Because their age is considered to be not yet of the right age to know the difference between right and wrong and the possible consequences of their act. That's why they called it the age of full irresponsibility. But take note, this child will be subjected to some form of an intervention program. Now, wherein the government, through the DSWD, will provide for a certain program that will uh, immediately address the cause or the reason for this child's misbehavior so that they can possibly correct the child at early age and becomes a responsible individual. Okay? The parents of the child will be responsible for the civil liability. Okay? So child 15-year-old below and those who are above who commits a crime are now called as the child in conflict with the law. Okay, now let's go to the third one. The third one is speaks of also minority, but this time the age is between what 16 and 17. The law said over 15 but under 18. But to simplify it, that only means 16 to 17-year old. This is now the age of conditional responsibility. Now, why it is called conditional? Because in this age, we have to consider one more element, and that is the element of discernment. Okay? Discernment is not different from intelligence, actually. In criminal law, we use intelligence as an element of felony or felony. But in child in conflict with the law, the term that was preferred was the term discernment. Okay? So, in order for a person to be held accountable here, he must act with discernment. So if the child 16, 17 commits a crime without discernment, he is just the same with 15 below. Exempted from criminal liability but subject to intervention program, and parents is accountable for the civil liability. But if he acted with discernment, he can be tried. The trial and investigation can proceed, but he has the privilege to have the so-called diversion program. But take note, diversion program can be given without court permission if the crime charge is not more than 6 years and 1 day of penalty. The moment the penalty for the crime or imposable penalty is 6 years and 1 day and above, diversion program can only be granted with the court's approval. Okay, and what is diversion program? It is a program of the DSWD that the child in conflict with the law will be transferred to the so-called Bahay Pag-asa, and he has to undergo certain rehabilitation and corrective programs so that he can be assessed later on and determined whether or not he can be returned to the community as a responsible individual. Okay? Normally, the moment the child reaches the age of 18, he will be returned to the court. And the DSWD who conduct the case analysis or study will have to submit the report, and that will be the basis of the judge to decide whether, one, dismiss the case and excuse the child, or two, extend the diversion up to the age of 21, or three, is to order the execution of judgment of sentence because he is found to be incorrigible. Okay? Incorrigible. So take note that in the case of this child 16, 17 who acted with discernment, even if the trial proceeded, there is an automatic suspension of the execution of judgment. Before, under PD 603, under the Child, Youth, and Welfare Code, suspension of sentence is to be applied. But in 9344, suspension of sentence is automatic. Now, the moment the judge decided to extend diversion to age 21, then at age 21, he will be returned again to the court, and the court will only have two options, either to dismiss the case or to order the execution of the sentence. Okay? Now, let's go to the concept of accident. Okay. Accident, as we said, is one of the exemption to the exempting, for the reason that when there is an accident, the person is exempted from criminal and he may also be exempted from civil liability, provided that it must be a pure accident. Okay? Okay. Now, accident is defined as the circumstances or occurrences, rather, that happens outside the sway of man's will, although it comes about through some acts or ours still lies beyond the bounds of humanly foreseeable consequences. Okay? And take note, one of the requirements is that the act must be performed lawfully with due care, and there is no intention to commit any unlawful act, and it must be by mere accident. Okay? Next, we go to number fifth. Okay? The fifth exempting circumstances is under the compulsion of an irresistible force. Now, what is eliminated here is the element of freedom of actions. Okay? Once the person performs an act against his will, the court said he is no more a man, but he is more of a tool. Therefore, the man who is responsible for the force that pushes this person to commit an act is the one responsible. Okay? Because he is the one who was in control of the other. Now, what are the elements of irresistible force? Or rather, under compulsion of an irresistible force. One, that the compulsion is by means of physical force. Take note, physical force, okay? Not just mere threat. Second, that the physical force must be irresistible, meaning it's so strong that the one being forced to do something has no possible alternatives. Third, that the physical force comes from a third person's. And to have that clearly elaborated, let's have an example. A gave a fist blow against C. So sinapak ni A si C and ordered C, no, by pointing a gun at the same time, ordered C to grab the bag of D. Okay, bag, not bad, bag. The C grabbed and took the bag of D by force. Now, in this scenario, it is very clear that a crime was committed. Yes, but C, who grabbed the bag of D, performs an act against his will. Why? Because of an irresistible force, the fist blow, no, supported by a gun pointed against him. So even if you put yourself to that kind of situations, you have no other alternative somehow, okay, but to go with the order. So in this case, a crime is committed by C. Yes, but C is exempted from liability. The one who is responsible for the crime is A, being the principal by inductions. Okay? So if the question is C committed the crime? The answer is yes, because the question is only crime, not the concept of liability. Take note again and again. That is the common error that we have in the study of criminal law. We mix up the commission with the liability. Now, these are two different matters. It doesn't follow that when a crime is committed, there is a criminal liability. And the good example of that are these seven circumstances under the Article 12. Okay. Now let's go to number 6. Under the impulse of uncontrollable fear of an equal or greater injury. What does it mean? This time, what push a man to commit an act against his will is not irresistible force, but due to uncontrollable fear. Fear of either equal or greater injury. So, what are the two elements? One, that there is a threat which causes the fear. And such threats, okay, cause a fear of an evil greater than, or it is at least equal to that which he is required to commit. Meaning, mas mabigat or halos kapantay sa bagay na pinagagawa sa kanya. Two, that it promises an evil of such gravity and eminence. Yun. And that an ordinary man could have succumbed to it. Okay? To better understand that, let's have an example. Senator De Silva ordered Cardo to kill Don Emilio or his family will die. So here, there is no physical force, but there is a threat. And the threat is so greater that his entire family might be sacrificed. So if that in that situation, if Cardo will execute the order against his will, he is not criminally liable, although he acted as a principal by direct participation. Now, if the question is, did Cardo commit a crime? The answer is yes. But is he criminally liable? The answer will be no, because Cardo's act is against his will. There is a complete absence of freedom of action. The one who will be responsible here, again, will be Senator De Silva, who is the principal by induction. Okay? The last one is the so-called persons who fails to perform an act required by law when prevented by some insuperable cause. So we are talking here about persons who are duty bound to perform a certain act. But he failed to perform his duty because of a reason that is so powerful that he cannot overcome it. That's the concept of insuperable cause. Now let's itemize the element. One, that an act is required by law to be done. Two, that the person fails to perform the act. And three, that his failure is due to some lawful or insuperable cause. Okay. To clearly understand that, again, let's have an example. A policeman who failed to file a case involving warrantless arrest. We know that in case of warrantless arrest, there is a prescription of 18 days, 18 hours. There is a prescription of uh, 12 hours, and there's a prescription of 36 hours. That's 12, 18, and 36 hours. 12 for light felony, 18 for less grave, and 36 hours for grave felony. And this is applicable to warrantless arrest, meaning the arrest is not by virtue of a warrant of arrest. But the reason why he failed to file the case is due to the calamity. For example, there was a national calamity which suspend all offices. So how can I file a case? The fact that there is nobody that can entertain my filing of a criminal action. So in this case, the policeman cannot be held criminally liable for arbitrary detention, although he failed to perform his duty. Okay, so that is the seventh circumstances under the exempting circumstances. Again, in these circumstances, the general rule, there is a crime. But because of the lacking of element in the commission of a crime, the person is exempted from criminal liability, but there is a civil liability with the exemption of paragraph 4, and that is what? Accident. Okay? So that's it for our So we will be coming up with the next video for the mitigating, aggravating, alternative, and absolutory cause. But we will be proceeding first with absolutory because absolutory cause is almost the same with exempting somehow, but with a little difference. And the difference is that the basis of the exemptions. Okay? And this absolutory cause is not found in one article. It is spread out throughout the book 1 and book 2. So thank you. God bless. Keep safe. Observe physical distancing. Don't forget to wear your mask and wash your hands. Okay? So don't forget to subscribe and click the button. Okay? For the succeeding notifications of my video presentation. Thank you and God bless.